guys, and welcome to the Legist Law channel. Now in this session, I'll continue with the constitutional review, and in today's session, we'll look at the defense of the Constitution. It's a very important topic. Now remember, under Article 1, Clause 1 of the 1992 Constitution of Ghana, the sovereignty of the state is vested in the people of Ghana, in whose name and for whose welfare the Constitution sets up the arms of government with their powers, their functions, and also the limitation on their powers. Now, the Constitution also governs the relationship between the people and the state. Now, this Constitution is actually a document, but it isn't an ordinary document. Remember, the Constitution is supreme over every arm of government, over every state, over every institution, and over any person, or law, or action, or mission. Therefore, if any of these are inconsistent with the provisions of the Constitution, it will be declared null and void. So one of the easiest means of defending the Constitution is taking steps to enforce the Constitution against persons or organs or actions or missions that are inconsistent or that are acting inconsistently with the provisions of the Constitution. This is taken under Article 2, Clause 1 of the 1992 Constitution. In the previous session, I clarified that the word any person means any citizen. So under Article 2, Clause 1 of the 1992 Constitution, any citizen can bring an action to defend the provisions of the Constitution by seeking a declaration from the Supreme Court that something is inconsistent with the provisions of the Constitution. Now, you have to understand that the Supreme Court is the apex court. Yet, the Supreme Court's decision might actually be disregarded by the authority. So there must be a means of defending the Constitution by ensuring that if a person refuses the order of the Supreme Court, the person will be punished for it. This will deter other people from refusing the orders of the Supreme Court. So under Article 2, especially Article 2, Clause 5 and others, they provide punishment known as the high crime. So under Article 2, there is particular provisions dealing with high crime. Now the offense of high crime is simply disobeying or refusing to comply with the orders of the Supreme Court in regards to the enforcement of the Constitution. Now if a president or even if a vice president disobeys the orders of the Supreme Court, that person can be impeached. Now remember, under the Constitution, Article 57, there is a statement in there that the person who is usually highest in the particular state of Ghana is the president, followed by the vice president, and then followed by the Speaker of Parliament, and then the Chief Justice. So this basically means that if the president and vice disobey the Constitution and they can be impeached, the Speaker of Parliament, the Chief Justice, the Electoral Commissioner, the Auditor General, the Special Prosecutor, and anyone, even a minister or a member of Parliament, who disobeys the orders of the Supreme Court can be removed from that public office. In fact, in the same Article 2, it is provided that they will not be able to resume that public office for a period of 10 years after they serve their prison term. Now, it also means that any person who disobeys the orders of the Supreme Court is likely to serve a prison term of up to 10 years. And after the 10-year term, or after the period of the prison term, the person will not be eligible to enter or occupy any public office in Ghana. So this is one of the easiest means of defending or protecting the provisions in the Constitution. Another means by which we defend or protect the provision in the Constitution is by instituting the offense known as high treason. Now, high treason is an offense against anyone who seeks to derogate or overthrow or abrogate the authority of the Constitution. Sometimes the person might try to overthrow the arms of government or change the Constitution in the way or manner that it doesn't provide for. Now, under Article 289 of the 1992 Constitution, it is expressly provided that the Constitution can only be changed by an act of Parliament by the provisions that follow it. Article 290 for the entrenched provisions and Article 291 for the non-entrenched provisions. So this basically means that if anyone seeks to change the Constitution, the person must comply with Article 289, 290, or 291. Now, another point to note is that where the person doesn't comply with this provision and is trying to use force or violence or trying to use any dubious means to overthrow the arms of government or to change the provisions in the Constitution, that particular person is committing an offense called high treason. And for high treason, you are likely to suffer death if you are held guilty of that particular offense. Now, it means that any person who disrespects the authority of the Constitution and tries to abrogate or overthrow the Constitution of Ghana is likely to be severely punished. This was established also in two cases: the case of State and Autry, and also the case of the Republic versus Dr. McPalm. So these two cases establish that anyone who commits treason, right, can be convicted by the court and is even likely to suffer death for that particular offense of treason. Now, in this sense, how or what court actually, convicts these particular persons is actually the High Court, constituted of 3 justices. This is provided for under Article 19 of the Constitution. Also, Article 19 gives more elaboration as to what constitutes high treason. Now, it's also important to note that another means of defending the Constitution is also by placing a responsibility on Ghanaians to actually take steps to defend the Constitution. This means under Article 3 Clause 3 that provides for high treason, there is also Article 3 Clause 4 that places a duty or responsibility on all Ghanaians to act towards the defense of the Constitution. This means that even where the Constitution has been abrogated or overthrown, it doesn't mean that the Constitution has been nullified completely or the Constitution no longer exists. The Constitution, especially or specifically the 1992 Constitution, can be restored into power by the Ghanaian citizens. It means that there is no way by which we need a new Constitution. When there is an abrogation, we simply need to restore the 1992 Constitution. So this duty is placed on us to do everything in our power to defend and fight for the Constitution against those who want to commit the coup or those who want a revolution. And any crime or any loss that we suffer, right, will not be binding on us. It means that that particular liability will not be enforceable against us. In fact, when the Constitution has been restored, we can apply for compensation from the courts. This means that the compensation, right, will be paid from the consolidated fund by a court order, right, to encourage people to defend the Constitution of the land. The final thing that you need to note is the cases. That is the case of MPP versus Attorney General. This is known as the 31st December case. In this particular case, what simply happened was the fact that there was an overthrow of the previous constitution, that is the 1979 constitution, and that overthrow occurred on the 31st of December. Now, the new government, under the 1992 constitution, decided to celebrate the coup d'etat or the overthrow that occurred on 31st December, I think 1980 or 1981. So what then happened was that NPP, that is a political party, brought an action to defend the 1992 Constitution. According to NPP, if there is a responsibility placed on citizens to defend the Constitution, it means that there is also a responsibility not to celebrate the coup d'etat. So the state ordering for a mandatory celebration of the coup d'etat with public funds is inconsistent with the provisions of the Constitution, and the court actually agreed. So this implies that even the celebration of a formal coup or the celebration of a revolution is inconsistent with the aims and objective of the Constitution, which is that every citizen has a duty or responsibility to defend the provisions of the Constitution. The final case I'll give is the case of Equam versus Penin. Now, in this particular case, the defendant actually, per the overthrow of the 1979 Constitution, he claimed that he acted to defend the Constitution and was put in prison for it. Now, in a new Republican state, that is Ghana, the Fourth Republic of Ghana, he tried to take a particular office in the political party of the NPP. Now, one of the criteria is that you shouldn't be formally imprisoned or you shouldn't be convicted of a particular offense. But he was convicted of it. Now, the issue was whether or not his liability has been cleared because of the fact that under the 1992 Constitution, if you act to defend the Constitution, then your imprisonment or your punishment or your liability will be cleared. Now, in this case, the court held that he didn't act to defend the 1992 Constitution. He acted to defend the 1979 Constitution of Ghana. That is why, under the 1979 Constitution, they didn't provide any, remedy for any crime or loss that you incur in the defense of the Constitution, unlike the 1992 Constitution. So this means that although he incurred a crime or loss in the defense of the 1979 Constitution, that Constitution no longer exists, and so that particular punishment is still binding on him, and he cannot rely on the provisions in the 1992 Constitution under Article 3, Clause 5 to 7. Now, it's also very important to note this, this important case. That is the case of Salah versus the Attorney General. The court applied what is known as the continuity theory. So it's Salah versus the Attorney General. So the court applied what is known as the continuity theory, that the mere fact that there is a revolution or a change in government or an overthrow of government doesn't necessarily mean that there is a complete change in the legal order of the state. It's very important to note. So these are the authorities and the case references that provide that we are under a duty to defend the constitution of the land. And anything that we do that is inconsistent with the constitution, a citizen of Ghana can bring an action against us for a declaration of an order to protect the constitution against our actions. And if you disobey the order of the Supreme Court, you are likely to be punished for high crime. And if we act to overthrow the constitution, we are likely to be punished for high treason. Thank you so much for joining this session. There will be other sessions that will be made available. And so I would like you to share, like, and subscribe. Till next time, tada!